Hello, Kelly Blatnick with Blatnick Law here to discuss settlement issues. Many clients and parties have the mistaken understanding that once everyone agrees in the email string or the verbal agreement upon a dollar figure, everything's done and settlement is ready to go. No. Settlement, or at least agreement on the dollar figure, is generally speaking the easiest and first step. Depending upon the age of the parties involved and the nature of the litigation, will control and govern as to what settlement documents need to be signed. First and foremost, all parties to the litigation need to sign a settlement agreement and release. The settlement agreement and release states that all the parties are releasing each other party from any liability associated with the claims regarding either the litigation or the dispute. Settlement agreements can be signed prior to the filing of litigation. If a complaint or a petition has been filed, the settlement agreement must be agreed upon and signed by all parties, and many law firms call these agreements settlements and releases because all the parties are releasing each other from liability associated with the claim. After the settle agreement is signed and agreed upon, then the parties need to effectuate what occurred in the settlement agreement, meaning if someone needs to pay someone, that payment needs to occur. If a property transaction needs to occur, the property transaction needs to occur before the stipulation and order of dismissal. The stipulation and order of dismissal comes after all the parties have done what they said they would do in the settlement agreement. A couple of the tricky parts of the settlement agreement are sometimes one party wants the agreement to be confidential, whereas the other party does not. Other issues that usually get parties into trouble when they're trying to do a settlement agreement is, aside from the confidentiality, is the non-disparagement. Many plaintiffs want to go out and say, this company did XYZ to me and I sued and I got X number of dollars. But the company doesn't want the public at large to know that. So oftentimes in settlement agreements, the settlement agreement will say not only confidentiality, meaning you can't talk about the litigation, you can't talk about the dispute. There's also a confidentiality as to the amount of money that you received. And then there's also a non-disparagement, meaning you can't go around telling people that this evil company did things to you and you got money. So those are a couple of clauses that people need to look out for in the settlement agreements and releases. And to keep these clauses in mind, when a dollar amount is agreed upon, the person receiving the money needs to keep in mind that they're probably going to have to agree to keep quiet about the dollar amount and also not say anything bad or negative about the other party. And usually that's a bilateral agreement. No one says anything bad about the other party. So congratulations when you reach a settlement figure. But keep in mind, that's just the start of a bumpy road to get the settlement agreement and release, the stipulation and order of dismissal. And if you have a minor involved, there are many other issues that will be covered in another video. So just keep in mind that when you reach a settlement number, that's just the beginning. And there will be many other steps prior to actually receiving and being able to cash the check and being done. If you like my channel, please feel free to subscribe. And if you have any issues that you'd like me to discuss, please write the name of the issues in the comments below, and I will try to get a video out regarding those different facts.